Professor Namyong Lee's long-form commentary, Siron, Are Trump's Emergency Power Tariffs consistent with international commercial ethics, lawful under international law and U.S. federal law? What will the U.S. Supreme Court decide? And how would each outcome reshape Korea-U.S. trade and commercial dealings? The questions our citizens are asking are not emotional reactions but four connected issues: appropriateness, legality, the judicial outcome, and the commercial impact. First, can these measures be justified under the ethical standards of international commerce, predictability, non-discrimination, and transparency? Second, are they lawful under international law, particularly the rules of the World Trade Organization, WTO, and the core norms governing tariffs and discrimination? Third, are they lawful under U.S. domestic law, especially whether the International Emergency Economic Powers Act, IEEPA, can serve as a legal basis for imposing tariffs? Fourth, regardless of what the U.S. Supreme Court decides, how will Korean firms' pricing, contracts, customs clearance, refunds, and supply chains change? As of January 10, 2026, this is not the stage to assert that the Supreme Court's conclusion is settled, but rather the stage to define the plausible range of outcomes and prepare for the operational shock specific to each outcome. Let us begin with international commercial ethics. Ethics demands minimum standards for trade rules even before a court declares illegality. In cross-border commerce, the ethical core is predictability, non-discrimination, and transparency. When tariffs operate under rational procedures and clear criteria, firms can plan prices, delivery schedules, inventories, exchange rate exposure, and funding. When tariffs swing rapidly on a short cycle under an emergency narrative and are applied broadly, market participants end up running contracts on speculation rather than planning. At that point, the dominant cost is no longer the tariff rate itself, but an uncertainty premium. The most criticized aspect of Trump's emergency power tariffs from an ethical perspective is that the speed and breadth of policy changes undermine contractual predictability. That said, the ethical judgment is not tariffs are always unethical. If a tariff measure is limited, has a clear purpose and criteria, respects non-discrimination and transparency, and is subject to procedural controls, it can be ethically justified. The issue is how fully the current tariffs meet those conditions, and that answer leads directly into legal scrutiny under international law and U.S. domestic law. Under international law, namely the WTO framework, the issues become sharper. As a matter of principle, the risk of dispute rises when tariff increases exceed bound commitments, concessions, or when discriminatory application disadvantages specific countries. The baseline framework is the General Agreement on Tariffs and Trade, GATT, within which non-discrimination principles such as most favored nation treatment, most favored nation MFN operate. However, the WTO system also contains exceptions, and the national security exception is a prime point of contention. There are 2 points businesses must not miss. First, the national security exception cannot be reduced to automatic immunity whenever a country declares it. Second, even if an international law assessment is rendered, it does not automatically invalidate the tariffs under U.S. domestic law. In business terms, the significance of the international law frame is the risk that the United States may lose international legitimacy and enter a prolonged phase of retaliation and dispute, which can worsen supply chain costs and market access conditions. Therefore, the international law frame should be interpreted less as a short-term profit and loss variable and more as a medium to long-term market structure risk. Now we move to the core, U.S. domestic law. The current controversy centers on the question under U.S. domestic law of whether tariffs can be imposed under IEEPA. Tariffs are inherently a form of taxation, and they sit in tension with the constitutional principle that taxation is fundamentally a legislative power. For that reason, tariff imposition requires clear delegation and procedures. This is why at the lower court level, a line of decisions has formed in which the U.S. Court of International Trade, United States Court of International Trade CIT, and the U.S. Court of Appeals for the Federal Circuit, United States Court of Appeals for the Federal Circuit, have pushed back against using IEEPA as a comprehensive legal basis for tariffs. The Congressional Research Service, CRS, a congressional research body, has also organized the relevant issues and the structure of judicial reasoning. The point is straightforward. Even if emergency powers exist, the legal boundary is whether those powers extend beyond the category of import regulation to include a quasi-tax in the form of broad-based tariffs. What viewers are most directly curious about is the question, what will the Supreme Court decide? At the present stage, the most rational answer is narrow the plausible outcome set to 3 and calculate the operational shock. The moment one asserts a definitive conclusion, firms are forced to bet in one direction, and in tariff disputes, betting often turns into losses. First, the Supreme Court broadly upholds the IEEPA-based tariffs. In that case, the key risk is not the tariff rate itself, but the permanentization of authority. If the court's signal is that the executive branch can rapidly design tariffs under an emergency frame, tariffs will be used more frequently as a negotiating lever. The direct effects on Korean firms appear in 4 areas. Buyers will treat tariffs as a standing justification in price negotiations. Without contractual provisions allocating tariff burdens and setting price adjustment triggers, disputes will recur. Customs responsibility and the status of the importer of record will become the nucleus of bargaining power. As supply chain relocation pressure rises, country of origin and assembly or processing stages will translate directly into cost. The conclusion is that firms lose if they view tariffs only as costs, but they endure if they treat tariffs as contract variables. Second, the Supreme Court finds the IEEPA tariffs unlawful or beyond executive authority. The market's first association is tariff repeal, but the first operational shock firms actually experience is refunds and reconciliation. In reports and market estimates, the accumulated IEEPA tariff amount is discussed at around $133.5 billion, and the potential refund impact is sometimes discussed in a range of $150 to $200 billion. The practical essence here can be stated in one sentence. Refunds are not automatic cash for the supplier. They are a reconciliation game shaped by importer rights and documentary consistency. In general, US importers file and receive refunds. That gives buyers an incentive to demand lower the unit price first because refunds may become available. Conversely, buyers may demand that suppliers share the risk and cost of the refund process. In other words, even if the tariffs are held unlawful, Korean firms' margins do not automatically improve. The conditions for protecting margins are pre-negotiated contract provisions, customs documentation, classification consistency, and origin documentation consistency. Third, the Supreme Court does not resolve everything at once, and instead issues a partial ruling, remands with standards, or narrows the scope of enforcement. For firms, this is the most unfavorable case. The reason is simple. The longer uncertainty persists, the more buyers shift the uncertainty into unit prices, delivery schedules, quality liability, and inventory burdens. In this scenario, the core is not price, but logistics and customs timing, because shipment timing and customs entry timing become the starting point for allocating tariff burdens and determining refund eligibility. Now I will organize what specifically changes in Korea-U.S. trade and commercial dealings by transaction elements. First is unit price. Regardless of the outcome, unit price renegotiation begins immediately after the ruling. If tariffs remain, buyers will demand unit price cuts. If tariffs are invalidated, buyers will try to preemptively reflect refund expectations through lower unit prices. Therefore, the only reliable defense for pricing is a price adjustment clause in the contract. Second is contract structure. If Incoterms, international commercial terms, tariff burden allocation, price adjustment triggers, and refund reconciliation rules are not fixed in written clauses, disputes are inevitable. Third is customs responsibility. Importer of record status is the core of refunds, disputes, and documentary authority. When the importer changes, rights change. When rights change, money changes. Fourth is documentary consistency. If the harmonized system HS code, origin documentation, or customs valuation materials become unstable, refunds disappear, disputes lengthen, and the costs erode supplier margins. Fifth is the supply chain. Whatever the Supreme Court decides, the US market is likely to adjust trade terms under the premise that tariffs can recur. Firms must therefore pursue short-term shipment and inventory tactics alongside medium-term origin and assembly strategies. At this point, international commercial ethics and world best practices must be translated into execution systems. The language of ethics is predictability and transparency, but the language of firms is clauses and data. What leading global firms share is that they do not leave tariffs as a customs team issue. They elevate them into a profit and loss and contract system. First, they calculate tariff P&L at the order level and monitor margin sensitivity in real time. They attach item, origin, customs value, Incoterms, and importer status to enterprise resource planning, ERP, systems so they can immediately compute how much margin changes for this customer and this order when tariffs move by 1 percentage point. Second, they lock tariff and refund mechanics into contracts by embedding tariff burden allocation, price adjustment triggers, and refund sharing rules in an ex-post settlement structure. Third, they build documentary governance. They version control the bill of materials, BEM, origin rules, HS codes, and certification documents, and they enforce approval procedures for changes. Fourth, they use logistics and customs options inside the system. The Foreign Trade Zone, FTZ, bonded arrangements, re-export, and lawful classification optimization are not loopholes, but institutional design tools. Fifth, they institutionalize a war room. They create an execution system where sales, legal, logistics, finance, origin, and quality move as one sentence, and they fix the workflow into a one-page runbook from tariff event, contract clause activation, shipment, customs choice, reconciliation, refund processing. From the perspective of international commercial ethics, the biggest problem with emergency power tariffs is that they undermine predictability and transparency and structurally raise transaction costs. From the perspective of international law, they create tension with non-discrimination principles, and as the justification narrative weakens, the risk of a prolonged dispute and retaliation cycle increases. From the perspective of US domestic law, the key boundary is whether IEEPA can extend to a quasi-tax in the form of tariffs, and whether that collides with the constitutional principle of legislative taxing authority. The Supreme Court outcome can be compressed into 3 branches: 1. Uphold, 2. Unlawful, or 3. Partial remand. In any branch, Korean firms' profits and losses will be decided not by the ruling in the abstract, but by post-ruling negotiation and reconciliation. Tariffs are numbers, but what fixes those numbers into money is contract language, documentary consistency, and customs structure. Our citizens must also understand why the Trump administration invokes emergency power tariffs. Thank you for watching Professor Namyong Lee's long-form commentary